And this is People of the State of Michigan versus Joshua Baxter, docket number 20-780FC. And this is the time set for a not guilty by reason of insanity plea. And Mr. Baxter, we are going to start, if you would please raise your right hand for me. Okay, do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. You can put your hand down. Mr. Baxter, you have the right to be represented by an attorney. You are represented by Mr. Kaltreiter there. And Mr. Kaltreiter, you'll confirm for me this is a not guilty by reason of insanity plea. Is that correct?
That's correct.
And Ms. Allen, would you read the offenses, please?
In the People of the State of Michigan versus Joshua Baxter, file 20-780-FC, State of Michigan, County of Ingham. In the name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about September 11th, 2019, at 1550 Jacqueline, Delhi Township, Ingham County, the defendant did in count 1, willfully or maliciously burn, damage, or destroy by fire or explosive a building, structure, other real property, or its contents, and the fire or explosion resulted in physical injury to Joshua Baxter, contrary to Michigan law. This is a felony punishable by up to life or any term of years, and or $20,000 or 3 times the value of the property damaged or destroyed, whichever is greater. Per U.S. law, in order for the court to impose a fine of 3 times the value must be either proven at trial or admitted by defendant. And in count 2, did again willfully or maliciously burn, damage, or destroy by fire or explosive a building, structure, other real property, or its contents, and the fire or explosion resulted in physical injury to Joshua Baxter, contrary to Michigan law. This is a felony punishable by up to
the administrator, please call 119.
or life for any term of years and or $20,000 or 3 times the value of the property damaged or destroyed, whichever is greater. Again, pursuant to U.S. law, in order for the court to impose a fine of 3 times the value must be either proven at trial or admitted by the defendant. And in count 3, the defendant did willfully or maliciously burn, damage, or destroy by fire or explosive a building, structure, other real property, or its contents, and the fire or explosion resulted in physical injury to Joshua Baxter, contrary to Michigan law. This is a felony punishable by up to life or any term of years and or $20,000 or 3 times the value of the property damaged or destroyed, whichever is greater. In order for the court to impose a fine of 3 times the value must be either proven at trial or admitted by the defendant and was committed against the peace and dignity of the state of Michigan.
Mr. Baxter, the charges here against you are first-degree arson, 3 separate counts or 3 separate crimes of first-degree arson. Those are each felonies and each is punishable by life or any term of years. Have you had enough time to talk about these charges with your attorney?
Yes.
And do you understand the charges?
Yes, I do.
And we're doing a not guilty by reason of insanity plea. Do you understand that?
Yes, I do.
Do you have any questions about what it is that we're doing?
No, I don't.
Okay. Now, Mr. Baxter, even though you're pleading not guilty by reason of insanity, I do have to advise you that you're giving up your right to a jury trial. Or if you didn't want a trial by jury, trial by court, by judge that is, you'll also be giving up your right to be presumed innocent until proven guilty and to require the prosecutor to prove beyond a reasonable doubt that you're guilty. You'll be giving up your right to have the witnesses against you appear at the trial and to be able to cross-examine them, as well as the right to have this court order any witnesses that you might have to appear at the trial. You'll be giving up your right to remain silent at a trial and not to have your silence used against you. You'll also be giving up your right to testify at trial if you wanted to. Also, you won't have an appeal in this case the way you would if you had gone to trial and gotten convicted, because I'm not sure you can even have an appeal from a not guilty by reason of insanity plea. but even if you could, you give up a lot of issues that you could otherwise appeal, and you cannot appeal by right. Instead, you have to ask the next higher court to hear your case, and they would have to agree to hear it. Do you understand those rights that you're giving up?
Yes.
Also, Mr. Baxter, if I go through with this plea with you of not guilty by reason of insanity, you can't come back later on and try to say that this really isn't what I wanted to do today. Do you understand that?
Yes.
And you can't come back later on and say, oh, the only reason I did that was because there was some promise or threat or something that no one told you about today, Judge Draganchuk, but there was something like that that made me do it. You won't be able to say that. You understand that?
Yes.
Okay. Now also, Mr. Baxter, you need to know that if you plead not guilty by reason of insanity, it will result in your commitment for diagnostic examination at the Center for Forensic Psychiatry. That diagnostic examination could take up to
East
60
Nurse or aide,
days.
please take the family call on Park 1. East Nurse or aide, Park 1, please.
And after that evaluation or examination, a probate judge could order you committed to a hospital for an indefinite period of time. You understand those conditions as well?
Yes.
Okay. And has anyone promised you anything in order to get you to do this?
No.
Has anyone used any threats to make you plead or not guilty by reason of insanity?
No.
Is this your own choice, how you want to go today?
Yes.
Okay, and we are required then, next step, to have a hearing to establish first that the defendant committed the acts charged. And in that regard, I've been provided with the investigative reports in this matter that include the Delhi Township Fire Department's investigative report, as well as the Ingham County Sheriff's Office investigative reports. Is there anything else that the attorneys would have me consider for the finding that I'm required to make?
No, Your Honor.
Not from the defense side, Your Honor.
Okay, I have reviewed those reports in advance, and I find that all of these events occurred on or about September 11, 2019, at the location of 1550 Jacqueline in Delhi Township, Ingham County. On that date, at that location, first responders responded to that scene in a report of a massive explosion, and they found the home at 1550 Jacqueline to be fully engulfed in flames. The house had been almost completely destroyed as a result of an explosion that preceded the fire. Further investigation was conducted, and it was concluded that there was a blast caused by combustible gas. The fuel was identified as natural gas. They also discovered that there was a large amount of natural gas used at that residence on the gas meter on that date of September 11. And specifically that the gas had been flowing freely for almost 2 hours prior to the explosion. They also discovered in the course of the investigation that there had been damage to the natural gas line to the hot water heater in the basement, and that it was concluded that that was not accidental damage, but the direct result of an act by an individual. Mr. Baxter was the person living in the house at the time. Further investigation, well, I should back up. The leak from the gas line that they concluded was done by an intentional human act allowed the entire home to fill with gas until there was an ignition source and hence the explosion and then the fire. And further investigation led investigators to an individual who was a friend of Mr. Baxter's, and he had texted the friend on the date in question with a message that said, "And now look what I have done," with a picture of obvious damage to what appeared to be a gas line going to the hot water heater. Additionally, the text said, "I think the gas pipe in the basement is leaking. The house smells like eggs." And there was also a text that said, "I am explaining to my brother that this is not over." Those texts came from Mr. Baxter. Again, during the time period that gas was flowing freely in the house and just prior to the reported explosion and fire. And the house, in fact, was being occupied by Mr. Baxter following the death of his mother. And there was some kind of a dispute allegedly or disagreement between Mr. Baxter and his brother over the property. Furthermore, when the first responders arrived, Mr. Baxter was out on the ground by the sidewalk and driveway of the home, and he was very severely injured with burns as a result of being in the home at the time of the explosion and fire. So I find that the defendant, Mr. Baxter, did in fact burn, damage, or destroy by fire, which by burn means doing an act that results in the starting of a fire. So he intentionally opened or damaged the gas valve, causing the home to fill with combustible gas, and some ignition source in fact then started the subsequent explosion and fire. That the explosion and fire, the fire burned, damaged, or destroyed this real property, which was the home at 1550 Jacqueline. That from all of the circumstances, including the investigators' conclusions, as well as the text messages, that this was an intentional act by the defendant to burn, damage, or destroy the property. And then finally, that the fire or explosion caused physical injury to an individual, the individual in this case being Mr. Baxter himself. The next step in the hearing is that the court must find that the defendant was legally insane at the time of the offense. That finding has to be made by a preponderance of the evidence. I have reviewed the Center for Forensic Psychiatry report dated November 13, 2020, and the report does an extensive analysis of Mr. Baxter's prior history, which is extensive with regard to what appears to be diagnosed as psychosis and other delusional disorders and experiencing of auditory hallucinations. And the report, the examiner concludes that Mr. Baxter's actions and psychological state on the date of the offense met the requirements legally of insanity. And the investigator, or examiner rather, found that all of the legal requirements of insanity were met, and that Mr. Baxter was legally insane as defined by Michigan law at the time of the offense. And I will adopt that finding and make that conclusion as well by a preponderance of the evidence as set forth in the report. And has the court complied with MCR 6.302 and 6.304? Ms. Allen?
Yes, Your Honor.
Mr. Coltwriter?
Yes, Your Honor, you have.
And is either attorney aware of any promises, threats, or inducements that have not been already placed on the record? There having been none, but aware of any others that have not been mentioned? Ms. Allen?
No, Your Honor.
Mr. Coltwriter?
No, Your Honor.
Okay, the court finds that this not guilty by reason of insanity plea has been made voluntarily and understandingly by Mr. Baxter. There's been no undue influence, threats, or promises of leniency. It is supported by the findings that the court has made, and the court finds that Mr. Baxter is in fact not guilty by reason of insanity on counts 1, 2, and 3 of the information. And the court is required to forward a record of the findings and the hearing to the Center for Forensic Psychiatry, and the court will follow through on its obligation to do so. Is there anything further for the record, Ms. Allen?
No, Your Honor.
Mr. Coltwriter?
No, Your Honor. Thank you.
All right, then. Thank you, everyone. Mr. Baxter, you're all set here. You're done now for today, okay? Do you have any
Okay.
questions before we go?
No.
Okay, then you're all set. Thank you. Good luck.
Thank you.
Thank you, Mr. Baxter.